So it's a promise to pay only if there is any damage or any loss incurred in the process. In Hindi, it can be defined as क्षति की पूर्ति के रूप में धन देने की वचनबद्धता, which is the simple meaning of the word indemnity. So a person who has an indemnity insurance is said to have been indemnified. Now, why are we discussing indemnity in such details? There are 5 reasons. First is the Consumer Protection Act was applied to doctors very recently, and since that, patients have become a little more aggressive than what they were before. These kind of scenes are very common in OPDs and hospitals. Too many agencies have now, after that, developed powers to show us the red card. I have just enumerated 6 here on the screen before you. Medical Council, Consumer Court, Civil Courts, Criminal Courts, Human Rights Commission, and Competition Commission. So these are the agencies which have the powers to show us a red card. Numerous insurance companies have introduced indemnity policies. The current logos which I am showing you on the screen, most every company normally has an indemnity policy to offer to the doctors. And above all, the most worrisome problem is that the courts and commissions have pronounced dreadful judgments in the past. Because this is an online Zoom presentation, I cannot get a response from the crowd or from the listeners. But if I would ask, does anybody know what is the maximum amount of compensation awarded by an Indian court in a case that was filed on the Indian land for in the Consumer Protection Act? The answer is the compensation awarded was 12 crores. Actually, the compensation was 6 or 7 crores, and the interest accrued on the case until the time of disbursement was added up to the original compensation, and it became 12 crores. These kind of huge compensations have also suddenly brought indemnity in limelight. Indemnity policy is the only umbrella which can protect us against raining claims of negligence and dereliction. Every doctor loves to look like this and live a life like this, where he's happy, contented with his practice, with his revenue, and with the happy OPD and indoor practice. He likes to continue like this years and years together. But believe me, if an indemnity claim strikes, it has the ability of converting that good-looking, happy doctor into a complete pauper and impoverish him just simply because of the case. So whenever you receive a legal notice or court summons, now friends, I would like to differentiate here. There is a difference. I am sure most of the people, doctors or laymen, they don't understand the meaning between a legal notice and a court summons. If it is a legal notice, it means that if you don't fall in line, I am going to sue you. That is what a legal notice says. And a court summons is that now your opponent has sued you and now you have been called by the court to clarify your position in that matter. So either ways, court summons is a little advanced position than a legal notice. But whenever you receive any of these two, or whenever you have to go through a litigation, there are 7 major losses or problems that every doctor suffers. Those 7 are, I'll just enumerate all of them. There is a tremendous dip in self-esteem. There is huge embarrassment. There is a lot of emotional stress in going to the courts, drafting answers, talking to the lawyers, explaining them the situation. There is a social gossip that people talk about you and your bad case. There is a peer harassment. You can overhear people whispering about the problem that you have faced and the litigation that you are facing. And there is a huge amount of self-blame. Everybody goes through this. They keep on thinking about, if I would have done this, ye nahi hota, agar maine ye kiya hota, to wo nahi hota. Why did I do this? Why did I give that drug? Why did I not use this monitor? So n number of problems crop up in your mind, and there is huge self-blame. These are 6 out of the 7 that I told you. But nothing can protect you from all these 6 except a good friend or a good association. For example, now we are all anesthesiologists. Unless there is a good local ISA chapter and you have good friends in that chapter, nobody can help you in all these situations. There is only one thing, that is financial losses, and something that protects you from the 7th problem with a litigation, that is financial losses, is an indemnity insurance policy. Hence, practicing in today's world without an indemnity policy is blasphemy. So indemnity insurance is a hedge against a potential risk. Now, what do you mean by a hedge? I am sure everybody must have heard the word hedge fund or hedging. So what is a hedge? Hedge, the English meaning of the word hedge is a small tree or small bush. So like the man I am showing you here in the GIF, he's going and hiding behind the hedge. So an indemnity insurance is a hedge fund which helps you and protects you, behind which you can hide in your professional life. In case there are any claims of compensation, then that hedge or that indemnity fund can compensate or can make the payments and save you of the financial losses. This is called as indemnity so this is how indemnity acts as a hedge. Now, there are so many terms and terminologies related to indemnity insurance. I can go on blah and blah, blah, blah. I will just enumerate a few of them. I can see there are 43 participants in this listening to this presentation right now. Just answer yourself. I know I cannot listen to I can't hear your answers. How many of you have an indemnity insurance policy? So I'm sure more than 95% or almost maybe even all of you must be having an indemnity policy. So I will show you a few terms which I call as the indemnity jargon. And I will ask you the meanings of those terms. Indemnitor, indemnity, AOA, AOY ratio, retroactive date, claim made basis, occurrence basis, nose coverage, tail coverage, and runoff cover. These are some 10 or 11 terms that I am showing you on the screen. There are many more also. But please ask yourself, how many of you know the meaning of these terms? And if you have an indemnity policy, but you don't know the meaning of these terms, then believe me, you are no better than this man. Because by having a policy and not knowing these nuances related to the policy, like this man, only you feel that you are covered. This is the level of your indemnity cover that you are enjoying right now. So let us now, I will try and create an atmosphere where we will be debunk or demystify or deconstruct all these difficult terminologies and make it very simple. Indemnity, please note the spelling, it's a double E ahead of T. Indemnity. So what is indemnity? Who is an indemnity? A person, in our case a doctor, or an organization, maybe the hospital that you run, which is held harmless in a contract, is called as the indemnity. So in an indemnity insurance, the doctor is the indemnity. Who is the indemnitor? The party or the insurance company which holds you harmless or holds harmless a person or organization in an indemnity contract is called the indemnitor. The hospital is the indemnitor. The insurance company is the indemnitor. Now, please note the difference between indemnity ending in a Y and indemnity ending in a double E. The policy or insurance is called indemnity and the person who is indemnified is called as an indemnity. I hope there is a clarity on the terms indemnity, indemnity, indemnitor, indemnify, and indemnification. Let us move ahead and talk about limit of indemnity. Now, what is the limit of indemnity? The sum for which you are insured in an indemnity policy is called as limit of indemnity. The maximum policy amount in an indemnity policy is the other definition of the word limit of indemnity. But there are two more components we need to understand in the limit of indemnity. One is AOY limit and the other is AOA limit. AOY stands for any 1 year and AOA stands for any one accident. So the total limit of the indemnity policy per year is called as the AOY limit, and the maximum sum you want to be paid per accident is called as the AOA limit. I hope I'm clear here. Maximum sum you want to be paid per accident is the AOA limit. So if you have a 1 crore rupees policy and you want 2 accidents to be covered, then the corollary is that you want to be paid 50 lakhs per accident. This is what you have chosen when you purchase your policy. Once again, we are discussing limit of indemnity, and in that I have introduced 2 new terms, AOY limit and AOA limit. AOY limit is the limit of the policy per year, and AOA limit is the limit of the insurance reimbursement per accident, any one accident. That is the AOA limit. I will elaborate on this further. What happens is you have a 1 crore indemnity insurance policy. You believe that any compensation which the court slaps on you, if it is below 1 crore, it will be met by your indemnity policy. This is what each one of us believes. So you make a claim and the claim is denied. You believe that suppose let us presume that the claim was of 50 lakhs. You have a 1 crore rupees policy. You have made a claim. So why is it that your claim is being denied? You don't know the answers. I will try and tell you what the answers can be. First is validity of the indemnity policy. Now here, friends, sure, most of us who are listening to me now, when you hear the word validity of the indemnity policy, you believe that I am talking about validity in terms of time. For example, 1st January to 31st December is the validity. So temporal validity is what you imagine when I talk of validity. Am I right? The answer is that is not the only validity. There are a couple of more aspects to the validity of an indemnity policy, which I will elaborate now. In order to understand an indemnity policy in details, I would like to show you this picture of a pig. And I'm going to talk about this pig throughout my presentation. The first arrow which has just gone down before your eyes is the time when you have purchased the indemnity policy, when your indemnity policy kicked off. And the second arrow which went down before your eyes is the time or the date when the indemnity policy ends. Between the two arrows is the tenure of the indemnity policy. So what lies before the arrow is what is the time period before you bought the policy, and what lies after the arrow is the time period which came after the policy ended. Between the two arrows is the main part of your indemnity policy. Am I clear on this? Can I move ahead? Okay. So the once again, main part of the policy is between the arrows. Before the arrow is nose area, and after the arrow is what is called the tail area. Now, I will ask a small question in order to elaborate on this further. You have a friend, a doctor who has started practice 8 months ago, a young man who has started practice 8 months ago. Somebody tells this young man about what is indemnity and about what an indemnity insurance is, and that he should go for an indemnity insurance. He decides to buy a policy when he is 1 year into practice. So he takes 4 more months to think, mujhe lena hai ke nahi lena hai. At the end of 1 year, he decides, yes, I want to buy an indemnity policy. Now, I am asking you a question, friends. Can he be indemnified for the bygone year of practice before he bought the policy? Quickly give an answer to yourself, and I will elaborate whether you are right or wrong. You can judge yourself. Can this young man be indemnified for the 12 months that have lapsed before he purchased the policy? Can he be? In other words, can the period before buying a policy be covered in the proposed policy? I am sure most of you or most of us think that no, that cannot be covered. But the answer is yes, it can be covered. This kind of a coverage is called as nose coverage. What it means? The feature in an indemnity policy that covers professional acts prior to the purchase of the policy is called as a nose coverage. So the period before the first arrow is called as nose coverage. How much period prior is covered is stipulated in the policy document. So it can be 3 months, 6 months, 8 months, 12 months. I don't think it is more than 1 year. But how much period you want to be covered, should be covered in your indemnity, can be covered, you have to pay an additional amount in your premium. So friends, coming to the pig again. So the two arrows are when you buy and end the policy. That is the main part of it. Nose coverage is what you additionally purchase for covering acts before you started practice. Before you purchase the policy, after you started practice. But believe me, while buying a nose coverage, they will always take an undertaking from you that you have not received any litigation notice. You have not received any police case summons. You have not received any notice from any patient. If the answers to all the above questions are no, only then they will sell you a nose coverage. Okay. So this is what a nose coverage is. Now I will tell you what is a tail coverage. Now, from extrapolating from what I told you about a nose coverage, you can make out the feature in an indemnity policy that covers professional acts even after the policy is discontinued or cancelled or shifted elsewhere is called as tail coverage. I will repeat. When a policy covers professional acts after the policy is discontinued, it is cancelled, or it is shifted to another company, is called as tail coverage. Now I will, in order to understand the tail coverage better, I will try to tell you 2 more terms in indemnity jargon. First is occurrence-based policies. Indemnity policies are of 2 types. First out of those 2 types is occurrence-based policies. As the name suggests, they are policies which cover incidents that occur when the policy was in force, irrespective of when the claim is made or when the case is filed. Please try to understand. What is the name? Occurrence-based. Occurrence का मतलब क्या है? जो भी घटना है जिसके बारे में केस या जिसके बारे में नोटिस हमको मिला है. So the occurrence is the unfortunate event. So if that event occurs when your policy was in force, then an occurrence-based policy covers you for that claim, irrespective of the claim, when the claim is made or when the case is filed. So even if the claim is made after the policy has lapsed, even if the police case is filed after the policy has lapsed, the insurance company will still honor the policy if it is what is called an occurrence-based policy. I will rephrase what I just told you. Even if the tenure is over or the policy has been cancelled, the claims will be honored if the incident has occurred when the policy was in force. They are also called as long tail policies. Am I right? पॉलिसी तो खत्म हो गई है, पॉलिसी का ड्यूरेशन तो खत्म हो चुका है, लेकिन जब घटना घटी तब आपकी पॉलिसी फोर्स में थी और इसलिए और वो ऑकरेंस बेस्ड पॉलिसी होने की वजह से कंपनी इज स्टिल ऑनरिंग द क्लेम ड्यूरिंग दैट पीरियड. So what is it called? It's called a long tail because they have got a long tail. The pig's tail is very long. Am I right? So that is called, these are called as long tail policies. Once again, tail coverage after the second arrow, that is after the policy is discontinued or ended. And that tail coverage, if it is a long tail, it means it is covering you even when the policy is not in force because it is an occurrence based. Now the second type of policy after occurrence based is called claims made policy. What is a claims made policy? These are policies which are required to be enforced when the incident occurs as well as when the claim is made or the complaint is filed. This is called as claims made policy. जब घटना घटे तब भी पॉलिसी होनी जरूरी है और जब पेशेंट अपने ऊपर केस करे या पुलिस के पास जाए या कंप्लेन करे या नोटिस भेजे, दोनों घटनाओं के दौरान पॉलिसी फोर्स में होना बहुत जरूरी है. अगर आपकी पॉलिसी क्लेम्स मेड पॉलिसी है तो इसका मतलब क्या है? इन अ क्लेम्स मेड पॉलिसी टाइप ऑफ पॉलिसी देयर इज नो नोज कवरेज, देयर इज नो टेल कवरेज. देन अ क्लेम्स मेड पॉलिसी में the main part of the first policy has to be connected to the main part of the second, to the main part of the third, to the main part of the fourth. So पॉलिसी के बाद पॉलिसी के बाद पॉलिसी के बाद पॉलिसी रिन्यू होना बेहद जरूरी है. If the policy is lapsed and if it is a claims made policy, even if the event has occurred when the policy was in force, it will not be honored because when the notice came, the policy was not in force. Am I clear? So there is no tail coverage in a claims made policy. Now I will come to AOA and AOY. I just told you AOA stands for any one accident, AOY stands for any one year. AOA to AOY. I will give you an example. With a few examples, I'd like to explain to you how the AOA AOY ratio works. Now let us all the 49 participants or listeners who are listening to me right now, I will talk to you as if we are talking about a case you are facing. You have an indemnity policy of 1 crore. You have been slapped a compensation of 1 crore by a court. Am I right? Am I clear? Let us start step by step. You have a policy of how much? 1 crore. What is the compensation the court has slapped on you? 1 crore. Now you have an AOA AOY ratio of 1:1. So this compensation of 1 crore will be paid by the insurance company. Am I clear? Because 1:1. Now if the AOA AOY is 1:2, then it means that you have asked the company to cover 2 accidents in 1 year. पॉलिसी तो आपका 1 करोड़ का है, कॉम्पनसेशन तो कोर्ट ने 1 करोड़ देने के लिए बोला है, लेकिन आपने 1:2 चूज किया था जब आपने पॉलिसी खरीदी, तो इस वजह से आपको फॉर दिस एक्सीडेंट द इंश्योरेंस कंपनी विल पे यू ओनली 50 lakhs. Who pays the remaining 50 lakhs? You pay the remaining 50 lakhs because your AOA AOY ratio is 1:2. Now you understand that your policy is valid, but it is valid for 50 lakhs. And the additional 50 lakhs compensation slapped by the court, you will have to foot that cost. AOA AOY ratio of 1:4. In this situation, again, you have a policy of 1 crore, compensation slapped is 1 crore, insurance company will pay 25 lakhs and you will have to pay 75 lakhs out of the 1 crore compensation. Despite having a 1 crore policy, because you have chosen a wrong AOA AOY ratio 1:4, which means the insurance company expects that you expect the insurance company to cover only 1/4 of the insurance limit for each accident. So they are paying 25 lakhs. Now, after this 1 lakh, after this 1 crore compensation, you face another case in the same year. You have an indemnity policy of 1 crore. You have been slapped with a second order of compensation of 50 lakhs in the same year. We are just talking about a hypothetical situation. God forbid this should not happen with anybody. But if this happens, फिर से आपका 1 करोड़ का पॉलिसी है, पिछली बार एक कॉम्पनसेशन क्लेम हो चुका है, अब दूसरा क्लेम आपके ऊपर उसी साल में आया है and you have been slapped a compensation, a second order of 50 lakhs compensation. So what will happen? If you have an AOA AOY of 1:1, तो पिछली बार 1 करोड़ का कोर्ट ने कितना दिया था? इंश्योरेंस कंपनी ने कितना दिया था? 1 करोड़। अब दूसरा क्लेम 50 लाख का आया है. The court has given a second compensation of 50 lakhs. Who will pay? The answer is you will pay, because your limit is 1 crore, which has been exhausted in the past claim. Now the insurance company has nothing to pay, so you pay the second compensation which the court has slapped. Second example. If the AOA-AOI ratio is 1:2, insurance company has last time paid 50 lakhs compensation in the last case. अब ये दूसरी बार 50 lakhs compensation अभी कोर्ट ने स्लैप किया है. Second claim of 50 lakhs. Who will pay? Answer is insurance company, because you have a policy of 1 crore. Company has paid only 50 lakhs last time, and now again 50 lakhs is paid. Company will pay. You will have to pay nothing. But if you have an AOA-AOI ratio of 1:4, last time insurance company ने 1 crore में से 25 lakh दिया. Compensation was paid once. You have paid remaining 75 lakhs as compensation for the first time. Now there is second claim of 50 lakhs. Insurance company will pay 25 lakhs again, because yes, out of that, because and you will have to pay 25 lakhs, because out of 50 lakhs they have agreed to pay you 1/4 each for each accident. So 25 lakhs insurance company will pay, and you will have to pay 25 lakhs. Am I clear in this? AOA-AOI ratio determines the validity of your insurance also. AOA and AOI ratio of 1:5 and 1:6 is not available in the Indian market, because the Indian government and the IRDAI feels that अगर आप सोचते हैं कि आपके ऊपर साल में 5 और 6 केस हो सकते हैं, मतलब आपका स्ट्राइक रेट क्लेम्स का 2 महीने में एक केस है, तो आप प्रैक्टिस ना करो, इंश्योरेंस मत निकालो, प्रैक्टिस बंद कर दो. So this is what our government believes, that if you are expecting 5 and 6 cases, they are not allowed in our country. So AOA-AOI ratio of 1:4 is the maximum ratio available in the Indian market. Now I will again paint a hypothetical situation which will particularly be useful for the senior members amongst us, but also middle-aged people like me also need to know about this. Let us presume that you stop practice in June 2023. एक hypothetical situation की हम बात कर रहे हैं इस मुद्दे को समझने के लिए. If you stop practice in June 2023, you start enjoying a retired life, and since you have stopped practice, you don't extend your indemnity policy. 8 months later, that is 8 months after June 2023, you receive a notice for a case you did in May 2023. That is 1 month before you stop practice. Now, yours is a claims made type of policy. What will happen? I will remind for those who don't remember. Claims made policy वो है जब जिसमें the policy has to be in force when the event occurred, and also when the claim came, or when the notice was sent, or when the case took place, or when the judgment came. Every time the policy has to be in force, उसको बोलते हैं claims made. So you stop practicing June 23. The event is of May 23. Your policy was in force until June 23. So policy was in force when incident happened. But today you have stopped, you have discontinued the indemnity policy, and the notice has come. And yours is a claims made policy. What will happen? Your indemnity policy will be invalid. But now let us go 2 steps back and again come to the same. Again, same story. Practice stopped in June 23. Policy discontinued. Claim comes for an event in May 23. And yours is an occurrence-based policy. What will happen? Even if your policy is currently inactive because you have stopped practice, it is valid for that case because it was in force when the incident occurred. Because it is an occurrence-based policy. So have I made it clear that an occurrence-based policy and a claims-made policy, what is the difference? So friends, you have to have an occurrence-based policy if you have a choice. Now, yeah, retirement and coverage for period after retirement is, in order to understand that, you need to understand a term which is called runoff cover. This is another term in indemnity jargon. What is runoff cover? If you want to stop medical practice, you have a claims-made policy. Then for a valid indemnity cover, even after stopping practice. See now, claims made है, इसका मतलब क्या है? प्रैक्टिस बंद करने के बाद, पॉलिसी बंद करने के बाद, पॉलिसी आपको सपोर्ट नहीं करने वाली, तो आप पॉलिसी बंद नहीं करेंगे. आप क्या करेंगे? You will need to purchase what is called a runoff cover, because you want the policy to be in force even when you are retired, when you are not doing any professional acts, no professional work going on, but you want to be linked to the policy, because for claims which will come for period before you stop practice also, you want a coverage. So you buy what is called runoff cover when you stop practice. What is runoff cover? Run-off cover is an extension of the indemnity insurance which continues to protect or cover you for allegations of professional negligence after you are no longer practicing or you have retired. तो रिटायरमेंट के बाद प्रैक्टिस बंद लेकिन इंश्योरेंस चालू, ऐसा अगर आप करना चाहते हैं तो यू डोंट नीड टू पे द होल प्रीमियम फॉर द इंश्योरेंस एज यू हैव बीन पेइंग ड्यूरिंग योर करियर. You can pay lesser, and that is called run-off cover. Usually, the companies charge you for 2 years and give you a cover for 4 years. Sometimes they charge you for 1 year, they give you a cover for 3 years. So run-off cover is cheaper, but it covers you for a longer period when you have to commit that you will not practice, and that will cover cases only which have occurred before you stop practice. This is what a run-off cover is. Now, friends, I have told you AOA, AOY ratio, I have told you occurrence-based policy, I have told you claims-made policy, I have told you run-off cover, I have told you indemnity, indemnity or indemnification. Now, there is a common term which everybody uses, errors and omissions insurance. Friends, what are errors and omissions? Errors are acts of commission and omissions are acts of omission. Both of them put together are components of negligence. Errors and omissions covers negligence. Hence, it is also called as malpractice insurance. Therefore, errors and omission insurance is same as professional liability insurance, is same as malpractice insurance, is same as indemnity insurance. So all the words, all the names, the 4 names which have turned green on the screen right now, they mean the same, what we call as indemnity insurance. Uske naam alag alag hai. Some company calls them errors and omissions, some company calls them professional liability, some companies call them malpractice insurance, some companies call them simple indemnity insurance. Now, what is green and what is red? Green is what is covered in the indemnity policy. So all that is covered is all a big yes, yes, and all that is red is a big no, no. Now, what is covered in an indemnity policy? Professional negligence. Any sort of civil negligence is covered in a professional indemnity policy. Criminal negligence is not covered. If there is a criminal case against you made by a patient for loss of life, loss of limb, or murder, or rash and negligent act, or resulting in death, then that is a criminal case. Indemnity policy will not cover criminal case, but it will cover professional negligence. Second, it will cover loss of data or documents. If somebody sues you for loss of data or loss of documents, I can see somebody has raised a hand. May I request you to type your questions in the chat and we will try to answer the questions at the end. Or maybe Sinha sir can read those questions and ask me those questions later. Something we will do. But I will continue. Whatever questions you have, please chat. Before you forget those questions, please type them in the chat box and leave them there. We will try and answer them in the end. So if a patient sues you for loss of data or loss of documents, then that is also covered by an indemnity insurance. Unintentional breach of confidentiality is covered by an indemnity insurance, provided it is proved that the breach of confidentiality is unintentional. Now, what is unintentional? What is breach of confidentiality? Do you know, friends? For those who don't know much about these legal parlance, legal terms, you and the patient are bound by a contract of confidentiality. You are bound to keep all the health-related facts of the patient as secret. You are not supposed to divulge it to anybody, come what may and for whatever reason. So that is called as a contract of confidentiality. If you breach that confidentiality unintentionally, it can be covered by indemnity insurance. I'll give you an example. You are called at Dr. Kamat's hospital for an MTP on Mrs. Rao. These are all hypothetical examples. Okay, don't go by the names; they are just imaginary. So you are called at Dr. Kamat's hospital for an MTP as an anesthesiologist. On the MTP is on a patient whose name is Mrs. Rao, Mrs. Rao happens to be the wife of your friend Vivek Rao, who stays and works abroad. Now, you go, MTP goes well, you ascertain the well-being of Mrs. Rao. After the MTP, you ask her, are you fine, Mrs. Rao? And you depart from the hospital. A month later, you meet Vivek Rao at a dinner at the Rotary Club meeting. And after exchanging pleasantries with Mr. Rao, Vivek Rao, you ask him, so Vivek, how is your wife doing? And Vivek looks at you with a startled face and says, what's wrong with my wife? And then you say, oh, why? What do you mean? What's wrong? It's just about not even 20 days since back that I did an MTP on your wife, Mrs. Rao. And he is startled and shocked to hear this because he is not privy to this fact that she has undergone an MTP. Now, friends, now here, first, my question to everybody is now, again, this cannot be interactive. This is a Zoom talk. So I will like you to answer yourself. How many of you believe that what the anesthesiologist has done by talking to Mr. Rao about Mrs. Rao's MTP is professional misconduct. How many of you feel? How many of you believe that the husband need not know everything about the health of the wife, even if it is a matter related to pregnancy in wedlock or out of wedlock? How many of you believe that he has no right to be privy to these facts? How many of you believe? And how many of you believe that there is nothing wrong if the anesthesiologist says this to the husband of the patient? Now, this is a case which has happened with somebody whom I know in Mumbai. The pregnancy of Mrs. Rao was a pregnancy out of wedlock. Mrs. Rao had faltered in a weak moment of loneliness. Vivek did not know about this pregnancy. And your disclosure to Vivek Rao has brought a storm in the Rao household. And their marriage is about to break down. Now, Mrs. Rao is pissed off with you and she sues you in the court for breach of confidentiality. This is a case which happened in Mumbai with somebody whom I know. Now, friends, this is breach of confidentiality. You can be sued for it. But if you are able to prove that the confidentiality of breach was unintentional, if your utterance was unintentional, the indemnity policy can cover it. So, अगर आपकी इंडेमिनिटी पॉलिसी है और आपके ऊपर इस टाइप का कोई केस होता है तो पूरा केस चलेगा किस मुद्दे पे? ब्रीच ऑफ कॉन्फिडेंशियलिटी इंटेंशनल था क्या अनइंटेंशनल था? The whole case will run on this fact and you will have to prove in the court that it was a mistaken unintentional breach of confidentiality, and if the court upholds what you say, then your indemnity policy can cover you in this case made by Mrs. Rao. Defamation. There are two components of defamation, libel and slander. Slander is spoken defamation and libel is written or published defamation. So if you defame somebody on social media, it is libel. If you defame somebody verbally by saying something against that person in front of him or behind her back, but if you say something not right or published, it is called slander. Both defamation, types of defamation are covered by indemnity insurance. Defense costs means the lawyer's costs are covered by not only the compensation awarded by the court, the lawyer's fees are also covered by the indemnity insurance. And also, indemnity can cover out of court settlement, which is called Mandvali in Mumbai. If you go for a settlement with the patient out of court, and if your settlement formula says 10 lakhs of rupees to be given to the patient and he will withdraw the case, there are insurance companies which cover out of court settlements. Do you know that most of the insurance companies don't cover out of court settlements? Do you know that they don't cover, number one? And do you know why they don't cover? I will tell you the answer to both. The fact is that we are all thorough gentlemen. We are all sincerely neck deep into hard work for our patients and for the well-being of our patients. But there are black sheep in every trade and every place in the world. The insurance companies believe that if a doctor and somebody whom he knows hobnob with each other and the friend of the doctor sues the doctor in a false, vexatious litigation, claims 50 lakh rupees compensation, the case continues, and then the doctor and the friend come to an out-of-court settlement for 20 lakhs, and you go to the insurance company and tell them, now we have settled, he is withdrawing the case, and we have settled out-of-court settlement value is 20 lakhs, so please pay him 20 lakhs. What will the insurance company do? The insurance company does not want to encourage these kind of malpractices, or they believe that they have to have rules in place which will deter these kind of malpractices. Hence, insurance companies don't cover out-of-court settlements. But believe me, whenever a patient sues a doctor, everybody is charged. The adrenaline is running high. But when the case goes on for 5 years, 8 years, 10 years down the line, they get tired. Sometimes they send you a feeler through somebody, through some mediator, that we will try for an out-of-court settlement. And that is the time when even we are tired of the litigation. Even if you are sure you are going to be cleared of all the claims and all the allegations, still, if there is a possibility of out-of-court settlement, you want that to happen. Can you believe that your insurance company will say, no out-of-court settlement allowed? You run the case, let the case come to a logical conclusion, and then we will decide whether we cover the claim or not. So you have to suffer till the end of the case, even when the patient is willing for an out-of-court settlement. That is the fact of an out-of-court settlement and indemnity claim. Have I clarified it? So please try to find out if your indemnity cover allows you an out-of-court settlement. If it does, it is a good feature. Hona chahiye. It helps us. Now, what an indemnity cover does not cover. It does not cover criminal acts, frauds, and violations of law. it does not cover acts under the influence of alcohol or drugs while rendering medical services. If you are drunk and you make a mistake treating the patient and the patient ends up suffering some damages, it is not covered. Intentional damage of patient well-being is not covered. Means you get involved in some kidney racket, you deliberately jeopardize the interest of the patients intentionally, it will not be covered. And the last is, I'm just trying to cover because some very masoom people out of us should not believe that loan liability of an insolvent doctor will be covered by indemnity. If there is a loan which you have not paid, your indemnity policy cannot pay that loan for you. Now, what are the expenses covered by professional indemnity insurance? The compensation which the courts award. ये तो पक्का है, इसी के लिए तो खरीदते हैं हम, तो सबको पता है. Compensation which the court बोलता है 20 लाख रुपया compensation दो, so that compensation will be covered by the indemnity policy. It will cover legal expenses. What are legal expenses? Defense cost. Defense का मतलब क्या है? वकील के ऊपर किया हुआ खर्चा. That will be covered by the indemnity policy. Interest liability on the compensation. See, always cases go on for 10 years, 15 years, 20 years, anything. Let us say 10 years. So if the case is filed in 2024, the result will come in 2034. So the compensation, court believes that the compensation was due when the loss was caused. When was the loss caused? When the patient sued you in the court. So 2024 में आपका compensation due था, आपको देना बनता था, आपको देना चाहिए था 24 केस के चलते 34 में कोर्ट ने बोला अभी आप 20 lakhs compensation दो. So 24 to 34, 10 years interest on that compensation also you have to foot. So that interest liability also indemnity policy insurance company can cover. Out of court settlement cost insurance company can cover. There is something else which is very interesting. Supplementary expenses. Does your indemnity policy cover supplementary expenses? That is very important. I am sure none of the people who are listening to me know whether your indemnity policy covers these supplementary expenses or not. What are supplementary expenses? I will tell you two supplementary expenses. First is air travel or train travel to Delhi. Now, if I am from Ratnagiri, you are from Raipur, somebody is from Jagdalpur, somebody is from Durg, or somebody is from Pune. If the case goes to the Supreme Court, or if the case goes to the what is that, Delhi, the top consumer court in Delhi, the National Consumer Disputes Redressal Court. If it goes to the National Consumer Court, you have to travel to Delhi. So the air travel to Delhi or the train travel to Delhi also is paid by certain insurance companies, not by all, but some insurance companies pay for that air travel. Now, I am sure I will like to enlighten those people who are listening to me and who believe that who wants air travel? I can always pay for the air travel. We can all pay for the air travel. I agree. But what happens is when there is a big case against you, your hospital, suppose you are working in a multi-specialty or a corporate hospital, you are sacked from that hospital. You are not fit for doing private practice in the heat and dust of private practice. Your practice is half of what it was before. You're already suffering monetarily, economically. At that time, even an air travel bill also becomes a burden. If the insurance company can pay for your Delhi travel, it is welcome. Also, hotel stay costs in Delhi are covered by some indemnity insurance policy. When you go to attend a court case in Delhi, Supreme Court or the National Consumer Court or Human Rights Commission, your stay in Delhi can be covered by the indemnity insurance in a moderate, simple hotel. The cost, there is some limits laid down by every company, but they pay for your stay in Delhi. These are supplementary costs. आपको देखना जरूरी है कि क्या आपकी पॉलिसी ऐसे प्रकार के supplementary costs फुट करती है. Do they cover these expenses? Try to find out. Now, do you know that medical establishments also have an indemnity insurance? I am sure most of you know. For those who don't know, claims against hospitals are patient dropped from stretcher. It is not against a doctor, it is against the hospital. Or a baby sustaining burns in a warmer, it is against the hospital and administration. Deficiency in nursing services. So, if you are going to a multi-specialty hospital, try to find out that the hospital also has a indemnity policy, institutional indemnity policy. Now, everybody knows. Now, here I have tried to use a Hindi in Marathi. I am from Maharashtra, so in Marathi there is a saying that everybody wants to have a cow like this, you know, the one which is in the picture. Everybody wants to have a cow like this. छोटे सिंगों वाली, बहुत ज्यादा दूध देने वाली, कम आवाज करने वाली, कपिला नाम की, शुभ्र धवल, एकदम white, milk white, गरीब गाय. But believe me, these are all superstitions. ये अंधश्रद्धा है, ऐसी कोई गाय होती नहीं है. These are only stories. These kind of guys exist only in mythological stories. Similarly, a professional indemnity insurance also, which permits out-of-court treatment, foods, air travel bills, includes hotel stay, provides legal help, gives AOA, AOI ratio, whatever you want, good nose coverage, long tail coverage, cheap run-off cover, and all this at a low premium. This is mythical and fictitious. ऐसा कुछ नहीं होता. Out of all these demands that you have, if most of them are met, then that indemnity insurance policy is good. Buy that professional indemnity if it covers most of these. All to cover करने वाली कोई policy होती नहीं. So terms beyond the scope of today's discussion is hold harmless or save harmless. Now I will like to come to one small component of my talk today, last component. How much indemnity insurance is good insurance? Friends, what are the determinants? What is your specialty? I mean, by specialty, I don't mean anesthesia or surgery or medicine or plastic surgery. I mean pediatric anesthesia, neurosurgical anesthesia, plastic surgery anesthesia, or transplant anesthesia, or what kind of anesthesia? What is your area of practice? Area of practice, by area of practice, I mean whether you are practicing in Dadar, you are practicing in Thane, Navi Mumbai, or you are practicing in Malabar Hill, the costliest area of your city, of your town. What class of patients you serve? Do you serve the industrial patients, worker class patients, daily labor class patients, or do you serve celebrities and multi-millionaires? Because then the claims will be according to that. How many patients you handle per annum, and what you feel could be the maximum compensation claim you may face. Friends, that is one, these are all the factors which determine how much indemnity you should buy. Another determinant is, I want to tell you that the Consumer Protection Act was renewed or modified in 2019, and all the new provisions in the new Consumer Protection Act have made it a little more adverse for all of us. Before 2019, the District Consumer Court had a power of only 20-25 lakhs. Now it is up to 50 lakhs. I'm sorry, it used to be, when the law was made, it was up to 1 crore. But now, I want to change this in the slide, I have forgotten. The District Consumer Disputes Redressal Commission has a power of up to 50 lakhs. So, आपके जिले में बैठ के, sitting in your district, a patient can sue you for 50 lakhs. State Consumer Disputes Redressal Commission, 1 crore to 10 crore. So, अगर किसी patient को आपके ऊपर 5 crore का केस करना है, he has to go to the state capital. I am from Maharashtra. So, if a patient from my district wants to sue me for 5 crores, he has to travel to Mumbai and sue me and file a case against me in the State Consumer Disputes Court, because that is in the capital of the state. So, if you are from Chhattisgarh and you are staying in, say, Durg, or you are staying in Jagdalpur, then the patient has to travel to Raipur to sue you if he wants to sue you for more than 1 crore in a state consumer. And if the patient wants to sue you in the national consumer, wants to sue you for more than 10 crores, he has to go to the National Consumer Disputes Redressal, National Consumer Court. And only then he can sue you for 10 crores, he has to go to Delhi. But the sad part is that this is a new age of consumerism, and hence all the provisions of the law are in favor of the consumer. The consumer courts levy a maximum fee of 7,500 for any claim even about 10 crores. 5 crore का केस हो, 2 crore का केस हो या 10 crore का केस हो, पेशेंट को कोर्ट फी स्टैम्प केवल 7,500 रुपए लगता है. Because of which now it becomes very easy to sue and file indemnity claims or negligence cases. So my recommendation is indemnity insurance cover of 1 crore is the basic fundamental minimum insurance you have to have is 1 crore. Now, I am sure if somebody out of these questions has asked me a question, which company is best for indemnity insurance? The answer is, if you feel that I'm going to tell you a company X is good, it is a myth. There is no company which is good, there is no company which is bad. You have to negotiate. Your association has to negotiate, and every company has a provision to offer you the best possibilities out of all our demands. जो भी आपको any company which gives you a maximum out of all the provisions is a good company. There is nothing like ICICI is good and New India Insurance is bad, or Axis Bank is good and somebody else is bad. I'll end with the couplet. In Sanskrit it says, Chintaniya hi vipadam ada deva pratikriya nakupa khananam yuktam pradipte vandhina gruhe. I will elaborate for those who don't understand. Chintaniya hi vipadam, to think of a calamity before is the right reaction. Ada deva pratikriya is the right reaction. Nakupa khananam yuktam. Na means no, kupa means well, khananam means digging, yuktam means useful. It is not useful to dig a well when pradipte vandhina gruhe, when your house is already on fire and there is light all around because of the house on fire. Us waqt कुआं खोदने में कोई अकलमंदी नहीं है. You have to think of all the calamities before and be well indemnified by a good indemnity policy and cover yourself with a good policy. Thank you. I have said everything. Now, Sinha sir, will you read the questions or should I read? I will stop sharing.
Thank you, Nilesh, for
Yes, sir.
taking out time.
No, sir.
There are few questions actually.
Yes, sir.
So one question is how long we should keep run-off policy after retirement?
The answer to this is we are lucky to be anesthesiologists. I feel that 3 or 4 years is an ideal period for run-off cover. The most unfortunate people amongst our professional brotherhood are obstetricians because बच्चा पैदा होने के बाद 15 साल के बाद भी mental retardation के लिए लोग केस करते हैं और उसको जवाब देना पड़ता है obstetrician को. So we are lucky people. Anesthesiologists, I feel 3, 4 or 5 years maximum is good enough. It depends on your appetite. I think 3, 4 years is good enough.
Okay, another question is how much indemnity insurance you should have as head of the department, as many times all the liabilities can be labeled against him.
Yes, this is called vicarious responsibility. You are responsible for the acts of your juniors and your unqualified representatives. That is the unqualified doctors or the resident doctors who are not qualified. So obviously, तो इसमें तो इस सवाल का जवाब तो बहुत मुश्किल है. How much you should be covered? But as I told you, 1 crore is the basic minimum. 5 crore, 10 crore is also good. I mean, there is no harm. But you have to presume that everybody's liability can come up to you. So the more more you are insured, the better it is.
Nilesh, one point I would like to clear from you. Now with the 2019 CPA Act,
Yes, sir.
the patient can file the claim anywhere.
Yes, sir. Any place, any state, any district.
Yeah. So it is another burden for the doctor to go to that place for evidence or something is to happen.
Yes, sir. And even engaging a lawyer in that place whom he knows nobody there. So
Yeah.
this is really a big liability, big problem.
Is there any other point? Just a moment. Is there a ceiling to how long a case can go on?
No, there is no ceiling. In fact, 10 years that case can go on in the district court. After that, it can go on in high court, then in the Supreme Court, and your harassment can continue for as long as 25. There are cases when the judgments have come when doctors have expired also. Out of 4, 3 doctors have expired, and the poor little surviving fellow has to bear the brunt of the entire compensation. These kind of cases have also come up.
Yeah, because our judicial system is such that you never know when the will be going on.
Yes, sir.
When the claim is made, I don't understand what is the meaning of when the claim is made. Like somebody is asking what is vicarious liability.
Vicarious responsibility or vicarious liability is that though a particular act of negligence has not been committed by you yourself in physical presence by your own hands, yet you have delegated the responsibility to another person who, as your representative, has delivered the healthcare services in that scenario and has erred or has practiced negligent, has done some rash and negligent act, and he is liable for that negligence, then on his behalf, you are liable equally because you have delegated the responsibility to that person. You were responsible for the acts of that person, and you are he is your vicar, he is your representative, and he is doing some mistake. So you have to bear the brunt of that mistake. Hence, it is called vicarious responsibility. Responsibility of acts of somebody else whom you have delegated because of various reasons. If you have, this happens in a manufacturer, dealer also, this kind of vicarious responsibility exists. And doctor and junior doctor and interns and everywhere also. Nurses also we have a vicarious responsibility of the acts of our nurses also.
Similarly, I think hospital is also liable for acts of the employees.
Yes, sir.
Another point is if doctor expired, what happens?
He's absolved of all responsibilities. There are cases in which doctors have simply because they are not living anymore, they have been absolved of all the responsibility. Then the case ceases to continue. Who can be penalized then in that case?
Does the group insurance is more useful than individual or like ISA, AMC?
All group insurance are always more useful than individual because they are negotiated, provided they are well negotiated. Like for example, they can insist that now I know of an organization called Association of Medical Consultants in Mumbai. They pay a annual premium of a whopping 60 crores. So if a company wants that 60 crore rupees premium for a group of say 500 doctors or 900 doctors, if you want to receive that premium, then you have to accept what that company says, what that association says. So the association can progressively add points and clauses to the group policy. Like for example, the insurance company, first time you ask the insurance company to give out of court settlement, they will say no. But you keep on negotiating with them next year, next, and you tell them, look, we are talking to Oriental Insurance and they are likely to give us out of court settlement. Then they agree because they don't want to let go of the premium. So this kind of negotiability exists with group insurance or association insurance. But this is true only if the association has negotiated, has sat with them, and you have to sit with them multiple times, and day-long meetings have to be held because they don't let go of 15 rupees also very easily. So well-negotiated group insurances are good. Group insurances are good, provided the representatives of your association are smart enough, well-read enough, intelligent enough to know what to ask for from the insurance company and have really thrashed out a good formula for each one of the association members. Then a group insurance is good. A group insurance is always better than an individual, because individual ko kaun puchta hai? Who cares for an individual? If you go as a single individual, they'll say, this is the policy, these are the terms, accept it, take it or leave it. This is what they will say. But they will not say like this to Foxy. They will not say like this to AMC, जिसके 50 करोड़, 100 करोड़, 80 करोड़ प्रीमियम आने वाला है. So they will negotiate, they will talk, they will agree, they will lose some ground to you and they will retain some, but they will retain the customer. That is why group policies are better.
Another question is the head responsible only for residents or consultants as well?
No. Why would you be responsible for consultants? Because consultants are qualified people. You need not be responsible for them. They are responsible for themselves. And it is only for those people who are not qualified to deliver. That time it comes on the qualified person, the vicarious responsibility. Not for other consultants.
Another point is, so if the claim is made and the case goes on for many years, then till those years we have to keep our policy running.
Yes. Ideally, I will advise whatever policy you have, please keep it running for all those years. And if you retire, then you take the run-off cover for that many years till the case is decided.
It was about a 3-month-old complex congenital heart disease who had to undergo amputation due to arterial line taken intra-op. The child died after 10 years later. Can patients claim now?
No. If you will have, you will have to fight a well contested and well documented case in the court, but they will not succeed. They can go to the court and court will admit, because see, this is a new age of consumerism. Consumer is God in today's market. So if they go to the court will admit the case, but it will not stand in the court because arterial line taken 10 years back and the patient dies, so you cannot justify. It will be very difficult. Facts will have to be seen in this case, what has exactly happened in the interim period of 10 years. But if believe me, you have to understand one legal maxim. In a negligence case, your act of negligence has to be the proximate cause of the damage resultant on the patient. So if in this case, the death of the child is the damage and your arterial line is the proximate cause of that death, then and only then will you be penalized for that damage. If the purported or alleged act of negligence cannot be linked to the damage, then they cannot be asked to pay compensation.
Where are the details of the policies mentioned, like occurrences based otherwise?
Many times what they do is they just give you a simple document, 1-page policy. That also people keep under the mattress or deep in somewhere in the cupboard. You have to ask for the complete policy document and you have to read through it, the fine print also. Take 8 days to read. Do you know that every insurance policy, life insurance, health insurance, indemnity insurance, vehicle insurance, general insurance, fire policy, every insurance will be sold to you, there is a specific free look period. That free look period is 30 days, sometimes 15 days. In that time, you can read the policy. If you believe that what you were told is not what is written in the policy, if there is a variance between what the agent told you and what the policy actually says, you can return back the policy and seek a refund. That free look period, every policy gives. IRDAI, that is the regulatory body in India for insurance, provides this, because here also it is a consumer's market. We are consumers of the policy, so our rights are upheld. So you have the right to read the policy thoroughly for maybe 15 days. Some policies give 30 days. Ask the agent, Mary's policy may free look period. How long is the free look period? If he says 30 days, read the policy for 30 days. Take your time. Ask questions to your friends. Call up people like me. Find out what we feel about it. And then if you feel it is not good or not what you expected, return the policy and ask for a refund.
How long can a patient wait maximum to file a case?
That depends on the loss damage. Now, for example, if there is osteomyelitis in a limb, and if the osteomyelitis becomes bad and there is gangrene and this happens, he is traveling from one hospital to another for 6 months or 1 year. He can file after 1 year also. So there is nothing called as time bar in a case, provided it is in reasonable time and the longevity of filing a claim is satisfactorily justified by the patient. That I had to go for dialysis, I went into renal failure, then I had to travel to national capital, I had to get admitted in this hospital, then I went to that hospital, I was 20 for 1 month, then I was weaned out of the 20. If they give such explanations, then any period later also they can file. But not 10 years and all, like they said, IV was taken, arterial line was taken intraoperatively for a child with a congenital heart. 10 years later, the child died. This is definitely time bar. This will not. But again, like I told you, it will still be admitted in the court, but it will not withstand the judicial scrutiny.
What is low down premium and for how much duration? Is this related to this, I think?
Load? No. I don't. Indemnity policy does not have any loading and all that. What this person who's asking this question means is probably it is related to health insurance, in which certain ailments are not covered for 6 months or 3 years, and then they will be covered after 2 years. That is called waiting period. There is no such thing with indemnity. Yes, sir.
Yeah. There are another questions about vicarious liability. I think you have already answered. Head of department is responsible only for the resident, not for the consultants.
Yeah, consultants. A qualified doctor who has been qualified by an examination in a university and who has already acquired the degree is he himself responsible for all the acts that he is doing.
So there's a one point is ISA can do that. ISA is not doing that, but indirectly they have had agreement with one insurance company provider. How much is liability of head of department? I don't know. Damage, exemption. Give clearance to PG Protect. Yeah.
Sorry, sir.
Ethics committee gives clearance to PG projects cases under the project. If any mortality occurs, is IC responsible?
Who? IC? Who is that?
Ethics committee.
No. Ethics see, we need to be very clear. Ethics committee is here not to say that whatever you do is not negligence. Ethics committee is here to say, is this kind of research ethical or unethical? If you say that I am going to give painkiller to the patient, I am going to bang his head 3 times, will that be ethical? The answer, the ethical committee is here to tell you, don't bang the head, don't do this study. Because under the effect of analgesic, even you cause harm to the patient is not allowed. So ethicality or the permission given by an ethics committee is only related to whether the research methodology is ethical, whether it fits in the moral and ethical gamut of medical practice. If yes, then you can go ahead. That does not give you an immunity from negligent acts or rash behavior or causing harm to the patient. So, in any circumstance, the ethical committee will not be held responsible for damages to the patient under research for which the ethical committee has given a green signal. This is very clear. Ethical committee is here only to decide whether the modus operandi you are going to implement in order to conduct the research is ethical. Is that allowed? Can we allow you to do that? Yes, it is ethical. Go ahead. Don't be negligent. They cannot say that negligence is also covered once ethical committee signal is there.
Next question is about the blood transfusion. Mistakenly, resident doctor transfused the mismatched blood and patient got blood transfusion reaction and following consequences. If it is claimed, who is responsible in court of law, whether the consultant or resident doctor?
If the resident doctor is qualified, he as well as the senior. If he is not qualified, only the senior.
So what happens? You have two indemnity policies. Should you inform both whenever there is case, or only one is at a time?
When you buy, you should inform both. First of all, when you buy, you should inform both. You cannot have compounding of policies. If you want, if there is any reason, you have to give the reason. Because see, I'll ask you one question. You have a policy with one company. The policy is for 50 lakhs of rupees. You feel that you want a 1 crore rupees policy. Why are you not going to the same company and asking for a top up of 50 lakhs? What is the reason? Why are you going to some other company? This smells um, of some dubious plans. Hence, first of all, you have to tell the first company that I am buying another policy from company. You have to tell company A that I am buying a policy from company B. And after that, if a litigation, if you confront a litigation, you have to inform both companies A as well as B. And then, if the compensation awarded is more than the the limit of one insurance company, then for the residual or the higher amount, balance amount, you can go to the company B. But only if both of the companies have agreed to co-fund your indemnity or to simultaneously indemnify you when the policy was in force and when there was no claim against you. If both companies have agreed, only then they will do this. Otherwise, they will not do it.
Next is, how long should hospital maintain papers?
So there is a specific period, 7 years, taxation for taxation purpose. For criminal cases, permanently. If it is a medical legal case, it is permanently. You cannot destroy at all. But otherwise, 7 years. All this, every state has different rules. So you can follow your state rules. But if there is a litigation, if it is a civil suit also, then forever, as long as the suit is not settled. When there is no case, then there is a period of how long you have to keep the papers. But if there is a medical legal case, if there is a notice, if there is a suit, then till the suit is settled, you have to keep every paper related to the case. How many ever years it takes?
Yeah, it is not a definite period depending upon the circumstances, I think.
Yes.
Yeah, in one case, child developed cerebral palsy. LSC was done for fetal distress. Mother is normal. Does anesthetist will have to pay compensation?
See, this is a very difficult question to answer because there will be a 90 bullet points discussed. Number one, was it meconium? What was the indication for the LSS? Was the baby immediately, did the baby immediately cry at birth or was it limp? Was the baby, did the baby take a breath? Was it pink or blue? Did you intubate the patient? Was intubation required? Did you fail in the first attempt at intubation? Did you intubate the patient? Were you successful intubating and did you oxygenate the baby? Was the baby, what was the APGAR score at birth? What was the APGAR score later? All these things will be discussed. And then, and only then, if it is proven that you should have done something more than what you have done, then you are likely to be held responsible for the cerebral palsy. Like I told you, your acts have to be proven to be directly responsible for the damages. So here, if you keep on, if your records are up to date and you have shown that the baby probably had reasons in utero to have developed cerebral palsy and they were not the reasons intrapartum which caused the cerebral palsy, then you can be absolved of that. But for that, your records, your details, and the way you put yourself in the court, your lawyers have to be very smart and very up to date. Then it can be disconnected. The occurrence of cerebral palsy can be disconnected from your acts, and you can be absolved of the responsibility.
Is ISA endorsed cover you policy occurrence based? Does it cover supplementary costs?
I don't know because I have not bought it. You'll have to ask them. They don't cover supplementary. Another thing with cover you is that when I ask cover you people, they said we do everything. They say yes to almost everything that you ask. But if you ask them one track record, one case where you have given lawyers to the doctor, they are not able to tell us. I ask them, give me one example where you have allowed out of court settlement. They say we will come back to you and they never come back to you. So I don't know about cover you, whether they have any example to quote. I believe that ISA should tell them that you give examples to our members. Tell us examples of doctors where you have given them legal support, where you have given them out of court settlement, where you have given them airfare or hotel stay in Delhi. If you have any such record, give it to us. We will like to know it. But if they don't have any previous track record, then they can be just empty promises also. They cannot be, nobody can vouch for it. Another thing is, I want to tell everybody that if you want all these things that we just discussed, you want all these covers, you want the policy to be good, then you have to be willing to give a hefty premium. You want everything and you want the premium to be low, that is not possible. If somebody is selling you that for a very low premium, I will give you everything. I will give you airfare, I will give you hotel stay, I will give you AOA ratio 1:1. How can it be? From where is the insurance company going to foot the cost of all this? So you are all very prudent, matured, intelligent, postgraduate doctors. Try to understand there has to be a direct link between how much you pay them and what you get in return. So there cannot be a policy which is very low premium. Stop getting fixed to low premium. The moment you have a lure for low premium, you will have to forego all the facilities in a policy. This applies to every policy, health insurance also. You want a low premium and you tell, many times I have heard my friends talking amongst each other, hey, you are a bloody fool. You bought a policy for 40,000 rupees premium. You are a nut. I bought a same policy for same value in 10,000 rupees. Obviously, such kind of policies are available. But do you know what are the sub-clauses in this policy? That health insurance policy will not allow you to get admitted in an apex hospital. It will not allow you to go in A category cities of the country. It will not allow you to go to Chennai, Mumbai, Calcutta and Delhi. It will allow you to go only to tier 2 cities. Do you know that health policies don't allow you more than 5,000 rupees of room rent per day if your policy premium is low? Do you know that health insurance policies don't allow you ambulance cost of more than 5,000 rupees per transfer if the premium is low? Whereas if you want any amount of ambulance bill to be paid, if you want any amount of ICU bill to be paid, if you want any amount of per day room rent to be paid, the premium is going to become fatter and fatter and fatter. So pay fat premiums and then ask for things. Don't expect many things in low premium. That is not possible. There is no free lunch in this world.
As you said earlier, that read your policy, what you are being provided.
Yes.
So, is there any guideline that anesthesiologist should be present in PSU for post-operative patients?
In PSU, in pediatric intensive care unit?
Most probably, I think. Post-anesthesia care unit, I think. PSU.
Post-anesthesia care unit. No, the post-anesthesia care, the post-operative care unit, the step-down ICU or whatever you call it, semi-intensive facility, will have doctors or anesthesiologists manning that facility, isn't it? So you are supposed to hand over the patient, give them the over and go for your next case. Why would you be expected to be there all the time? As long as the patient is settled, you cannot leave an unsettled patient who is going into hypoxia and walk into the OT for the next case. Obviously, if the patient is hypoxic, you need to ventilate, you need to intubate, ventilate, give 100% oxygen, increase the FiO2, see what is the cause for hypoxia, treat him and then go for the next case. But if there are other doctors to care for the patient in the intensive care unit, then you can always hand over the patient to them, tell them the details, and then you can go. Then you cannot you cannot be expected to be waiting there all the time.
One needs to do proper handover and documentation. Both
yes, document it.
Yeah.
Document it. Yeah. Proper handover and document it. Yes, sir. Right.
In continuation, the same, I think. What happens if something goes wrong to patient in PSU? Whose responsibility it is?
No. It is the doctor manning the PSU.
Yeah, if it has been properly handed over, then the person who is looking after. Can anesthesiologists be sued for damages caused by technology used during patient care, workstation, hemodynamic monitor, ventilator, etc.? Will the insurance company covers it?
Yes. No. See, one minute. We will split it into components. Can you be sued for technological failures or wrongful judgments of technology and monitors? The answer is yes. Because you are using technology, monitors and various interoperative devices and gadgets to make your life easy and simple, to be more efficient in your work. That does not mean that you have relinquished the responsibility of patient welfare. So if there is a BIS monitor, you are monitoring the awareness of the patient, you are monitoring the depth of anesthesia. If the depth goes out of control, you are supposed to immediately intervene and act. So because the monitor malfunctioned, you failed is not going to be entertained and you will still be sued for it. And after that, if you are able to justify that you did everything, but still, unfortunately, the patient's physiology did not support your efforts, did not work in tandem with the medications and treatment that you administer to the patient. If you are able to convince this, then the court will still award a compensation, but it will be covered by the indemnity as long as it is a compensation. You try to understand, there are two different words in English, compensation and penalty. That is why in an indemnity, what the court awards against you or awards the patient is a compensation. What is a compensation? A compensation is a word which means that you have not done anything wrong on purpose. You have not purposefully harmed the patient. You did your best to deliver what was most prudent from your knowledge, your education, and the patient's condition at that time available in that city in that period of time. But unfortunately, that did not help the patient. The patient still deteriorated and succumbed despite your efforts. So, but you have not inflicted death on the patient. You have not inflicted harm to the patient. But who is inconvenienced? Who is damaged? You or the patient? The answer is the patient has been damaged. Who will cover the damages to the patient? The court has to satisfy the wronged party, that is the patient. Hence, the doctor is asked to cover the damages by a compensation. They don't use the word penalty for the same reason. Penalty is used in circumstances when you are the perpetrator of the damages. You have caused damage, then you pay the penalty. But when you pay compensation, the court has almost accepted that आप कुछ जितना आपने किया उससे ज्यादा शायद आप नहीं कर पाने वाले थे, और या आपने जो कुछ भी किया उसके बावजूद पेशेंट का जो नुकसान होना था वो हो गया. तो it is a misfortune of the patient, but you please compensate the patient because the patient is inconvenienced. This is what compensation means. So the answer is, if anything of this sort happens and the patient is inconvenienced, you will still have to pay a compensation. That is why indemnity is there. And again, I am telling you, even among those doctors amongst us who are facing litigations, stop attaching stigma to it. Stop feeling sad about you having to face a litigation. Talk about it. Come out in the open. Talk to your friends. Have discussed it in the local ISA chapter. Talk about it and share it with your friends. Stop thinking that you are facing a litigation because you are some suboptimum, or you are less capable, or you are less efficient. Stop thinking about it. In the modern world of consumerism, litigations are a fact of life. Face them bravely and still do your work. You are still a wonderful anesthesiologist. You are a social asset. You are an asset of the nation. Keep doing your work and don't blame yourself and stop working. So, answer is compensation can still be given. The compensation is given to compensate the losses of the patient. Indemnity insurance है तो दे दो और अपनी आगे जिंदगी की तरफ आगे बढ़ो. भूल जाओ जो पिछला हुआ.
Another question similar about the responsibility. If a doctor is appointed as RMO and he is qualified MBBS doctor, will the consultant be responsible for his activities?
No. See, again here, if he's an MBBS doctor, it is okay, good. But the MBBS doctor was supposed to deliver care appropriate for his qualification. If there is some hypoxia, if there is a stridor, if there is a bronchospasm, if there is reduced air entry, he is supposed to call, he can treat under somebody's guidance, but he's supposed to call the superior doctor or the specialist doctor, and the specialist has to present himself physically at the site and treat the patient. If that does not happen, then merely because he was MBBS, you cannot be absolved of your responsibility.
It can be negligence if I have not done the proper calling the.
Yes.
Yeah. Next is because as far as I know, there is no particular guideline for posting anesthesiologists in PSU, and only trained staff nurses take care of patient, and in which case problem they call anesthesiologist. Actually, it will depend upon the status of how is the PSU, because there are quite different levels of PSU with different places.
Yes, if it is an intensive care unit, then the doctor has to be present. Sisters cannot be considered to be equipped. Sisters and doctors are not equipotent. You cannot say that a sister can replace a doctor. Similarly, an MBBS doctor and an MD anesthesiologist are not equipotent. The MBBS doctor can represent you or replace you temporarily with the caveat that you will present yourself at the site as and when required without reasonable delay, without unreasonable delay. So the fact is that you will have to present yourself. So intensive care centers manned only by nurses is definitely negligence. Intensive care centers have to be manned by doctors. Now, whether those doctors are qualified anesthesiologists or budding anesthesiologists or MBBS doctors, it depends on what level of intensive care that center is delivering. So if there are intensive care centers where anesthesiologists have to be present all the time, isn't it? So if the patients are so critical, definitely the anesthesiologist has to be there all the time. If there are patients on ventilator, definitely the anesthesiologist has to be there all the time.
It is related to, I think, cesarean pediatrician has to be present during anesthesia.
Yes, pediatrician has to be present. Neonatologist we call him. He has to be present.
There's one personal question to you. Which policy have you bought?
I have what the name which I took, Association of Medical Consultants Mumbai, group policy with AMC. I am a member of the AMC, that is Association of Medical Consultants, and they have a wonderful negotiated policy which allows out of court settlement, which gives supplementary expenses, and it has a very good features of the policy. So I have bought that. But again, that is a claims made. That is not an occurrence base. But this drawback I have to accept because the rest of the things are good. So I will have to buy the policy all the time.
Yeah, there are certain in the medical science is not a mathematical science, so there are certain gray areas always there. Another point is if an anesthesiologist is working as intensivist or pain specialist, and on the policy specialty mentioned is anesthesiology, will he covered as intensivist or pain specialist or not?
Yes, it will be covered. It will be covered. The discussion in the court will be: are you an anesthesiologist who was capable to render intensive care services? If this question is asked, let me tell you, if I am the lawyer of the patient, I will ask you, I will put you in the witness box and I will ask you, you are an anesthesiologist, what makes you qualified to deliver intensive care to the patient? What is the answer to this question? He will ask, I will tell you how he will deal with it. You are in the witness box. I am the lawyer of the patient. I will ask you, doctor, do you agree that there are postgraduate qualifications available in critical care? You will say yes. So you agree that there are specialists in critical care available in current era? You will say yes. Then are you a critical care specialist? Are you a postgraduate qualified doctor in critical care? You will say no, I am a doctor qualified, postgraduate qualified in anesthesia. So they will say, is postgraduate qualification in anesthesia synonymous with postgraduate qualification in critical care? Obviously, the answer you will say is no. Then the next question is, then doctor, what makes you qualified to deliver critical care services when you are not a critical care specialist and you are an MD in anesthesia? Then you will have to go back to the logbook of your residency. You will have to go back to the residency papers that you have and say that I have worked in a medical ICU, I have worked in a surgical ICU, or I have worked in a critical care unit in my hospital for 6 months. I have worked in a cardiac intensive care unit outside the cath lab for 3 months. And I have attended ISCCM workshops. I have attended these conferences. These are the papers. I have attended so many workshops. I have attended hands-on training. I have got trained. I have gone to this hospital for 6 months observership, 1 week observership, 2 weeks observership, and I am qualified by the virtue of all these top-ups that I continued in conferences and in my professional career. I equipped myself with the knowledge of critical care, and critical care was always a part of anesthesia. It is only in the last recent few years that postgraduate qualification in critical care is available. Still yet, the critical care specialists are statistically in minuscule minority. In my region, there will be a maximum of 10 critical care specialists in my state. Hence, I am the best bet in my city to deliver critical care. These are the papers. Hence, I am fully qualified to render critical care services despite being an MD in anesthesia. If you say this, this will stand the judicial scrutiny and that lawyer will not be able to do anything much provided your papers are right. Hence, friends, I am telling you, whenever centers of academic excellence hold workshops for observerships, hands-on training, or just didactic lectures and conferences, keep the documents of having attended those conferences. They can stand judicial scrutiny in the courts of law and you can be proven to be appropriately qualified for the job.
Keep your record updated.
Yes, keep your records updated and remember that being qualified is not synonymous with being skilled. I am qualified, but I am unskilled. I'll tell you a simple example. I am an MD in anesthesia. I am qualified for general anesthesia. I am qualified to give regional anesthesia. I am qualified to give spinal anesthesia. Am I qualified to give cervical epidural? Have I ever given a segmental spinal? So there can be questions asked to you. How many cases of cervical epidural had you done before this case, respected doctor? And if you don't have documents to prove that, you can be said to be qualified but unskilled for giving a cervical epidural. Am I clear on this? So you will have not only have to prove qualification, you will also have to prove skill. So where does the skill come from? Skill comes from conferences, workshops, observerships, and traineeships. If you have attended anything anywhere, document it. Laminate the documents, keep it firm and safely with you. You will have to produce it in the court of law at any stage of any litigation.
Nilesh, do I have time enough? We have still questions.
I can answer, sir. I can answer. If people are willing to listen,
okay.
I can answer.
Okay. If claim is made on hospital and 4 doctors team, some member expires, then how compensation is there?
See, the compensation, the courts are very clear. When they award compensations, they very clearly say that out of these 10 lakhs, 4 lakhs will be paid by the hospital because the hospital is responsible for A, B, C, and D diabetes. 6 lakhs will be paid by these 4 doctors. Now, out of those 4, if one has, as this question says, if one person is deceased, 3 doctors are alive, then the 6 lakhs will have to be paid by the 3 doctors who are alive. And what hospital has to pay? Hospital only will have to pay, whether they have an indemnity or they don't have an indemnity. So, अगर 4 डॉक्टर में से एक डॉक्टर एक डिसीज है, तो जितने 3 जिंदा है उनको they will have to share the responsibility.
Next is the average premium to be paid a fairly good coverage of 1 CR. We already discussed, I think.
Difficult question to answer. No, it is not a very difficult question to answer. So there are so many ifs and buts. There are so many features in the policy. The moment you keep on buying, see, it is like asking how much does a Honda City cost? The answer is anything from 9 lakhs to 20 lakhs. You buy buy TCS, ABD, EBD, what do you say, alloy wheels, 5th alloy wheel. The Stepney also has an alloy wheel. You buy, so you go on buying, adding features, your car goes on becoming expensive. So more features you buy, more premium you will have to pay. Very difficult to answer that for a 1 crore policy, a rational premium will be 40,000 or 50,000. This answer is difficult to.
Again, similar question about anesthesiologist working as critical care. Can he admit the patient under him?
Yes, he can admit the patient under him, provided if there is a litigation, he has to, like I just said, he should be able to substantiate that he is a qualified and a skilled critical care specialist. That is enough. If he does that, he can admit patient under him. Certainly.
Next is, will you be able to register as pain specialist in State Medical Council if you have attended pain conferences and hands-on workshops?
No. Medical councils have a precondition that the qualification has to be awarded by a medical council recognized institution / university. So DNB, MD, these kind of qualifications which are recognized by the medical council, only they are registered with medical council, state medical councils. Conference qualifications, workshop qualifications, observership qualifications are never registered on this. Even foreign university fellowships are not registered on medical councils. You will not see anybody's medical council showing an additional qualification registration of international fellowships. So fellowships are never registered with medical councils. Only university degrees and diplomas are registered with medical councils. But as this gentleman or this person has asked, if you have a fellowship or a pain residency program certificate that qualifies you to become a pain specialist. Your medical council need not recognize you as a pain specialist.
But you cannot write yourself as a specialist.
You should not, because it is not a qualification. Why you want to write yourself? Why do you
No,
want?
the-
You say MD
okay.
anesthesia and pain expert or pain practitioner or pain specialist. You can say that.
Because there are few cases in the past where medical councils have reprimanded people claiming them to specialists without qualification. And
Yes,
now
but
there is a official qualification of FNB in pain medicine.
yes. Now because there is no official qualification in pain medicine, exactly. So for areas where there is no official, now for example, if you say regional anesthesia expert, so there is no postgraduate qualification regional anesthesia available. So you can keep saying that as long as that is available. So I agree that if there is a qualification available, then you don't call yourself by that, but you can still practice pain and call yourself as an MD in anesthesia and practice pain because you have equipped yourself with pain management skills.
Actually, related to that, so legally we cannot practice interventional pain medicine.
No. You can, if you have acquired the skills, if you have sufficient documents to prove that you have acquired the skills in pain management, you can practice as pain practitioner.
Actually, now there is a lot of overlapping in
Questions,
particularly
yes.
the area of pain between
Yes.
neurologists, radiologists, and anesthesiologists, I think, interventions. So I think this is the last question. So thank you, Nilesh. Thank you very much for
Thank you. Thank you very much.
giving your valuable time, and it was quite elaborate. I think those who have not attended have missed a lot thing because I think there's a lot of unawareness about indemnity insurance. Like the question where they're like, which policy we should buy.
Yes,
This is
sir. Yes, sir. Yes, sir.
that is the biggest means block. Which policy, how much premium.
Sir,
Really,
now I have
Yeah.
also delivered a talk at a number of places. The title of
Yeah.
that talk is Dear Anesthesiologist, do you know what can land you in a courtroom? Now, these kind of questions, whether you can practice pain if you're an anesthesiologist, whether you can admit critical care patients under you as an anesthesiologist. I will ask you another question that has been asked to me like this. Can I do a general practice in a rural area if I'm an MD in anesthesia? Can I prescribe antibiotics to patients who go back home? Can I give them prescriptions like a general practitioner? So in that topic, I have tried to cover all these areas where in which I have described the content is anesthesiologist. Do you know what can land you in a courtroom? Can you issue medical certificates? N number of questions like this. But I feel that these kind of discussions repeatedly on various topics will make all of us wiser. I will liken this to a situation. I will remind everybody, we have all bought Maruti car in the past. Did you ever ask the Maruti car dealer, इसमें ABS है क्या, traction system है क्या, EBD है क्या, what, airbags कितना है? And today you know that your car has got 6 airbags and 8 airbags. So we have learned the demands because we have understood more about automobiles. Similarly, there will be a time when we will understand more about medical legal responsibilities and indemnity and patients' rights. Then we will not have these questions in our mind. We should have more of these kind of topics and discussions, after which our members and our friends will become more wiser in all these matters, and such questions will not come.
I would like to inform all those present here also, and to spread it, Nilesh is going to expand this activity, and actually now he is going to do workshop on this so that people
Yes.
can interact and properly understand about the insurance, indemnity insurance.
A minimum of 90-minute workshop on indemnity insurance I am going to hold. I am going to hold one at Ganga Hospital in Coimbatore. And anywhere if I am called, we can hold these kind of workshops where we will discuss everything and anything about indemnity insurance, what you need to know, how to buy an indemnity insurance, what to ask for, what to expect, what to accept, although you are not happy with it, still what to accept. There's so many things. How to buy a good indemnity policy, how to design and tailor make your indemnity policy. All this can be discussed, but for that we need a 90 minutes workshop in which I talk and people ask questions and answer. And there can be a question and answer session. There can be a small interactive session. So there can be a complete composite program of 90 minutes workshop or maybe a little more. But this kind of workshop on indemnity, one I'm going to hold in Ganga Hospital at GARC 25.
And hopefully we'll have it next national conference 2025 at
Yes,
Raipur
sir.
also. Nilesh.
Why not, sir? Why not, sir? Sure.
Yeah. There is one more question has come up. If the procedure is done by one anesthesiologist, nerve block, CV line, and further management done by number two, event happens, will due to previous procedure, who will be liable?
Both. Both. See, when the first anesthesiologist handed over the patient to the second anesthesiologist, he gave a complete over about the patient to the second anesthesiologist. The second anesthesiologist has summarily accepted the responsibility of this patient. So he cannot, or he or she cannot say that ये तो central line डाला था उसकी वजह से हुआ है. I am not responsible. It is a responsibility of both the anesthesiologists. Both will be summoned. Both will be grilled. Both will have to stand judicial scrutiny.
It will be available on YouTube. Actually, it is recorded also.
Yes.
There is another question. Can I give anesthesia for BAMS MS gynecologist? Very difficult question.
Sorry. What can I give anesthesia?
For Ayurvedic gynecologist MS.
Very difficult question to answer, but I feel that you should not, because if there is a mishap, then whether it was a surgical mishap or anesthesiologist mishap will be heavily debated, and you will also be asked what was the compulsion for you to go to, because even now the Ayurvedic surgeons are expected to work under supervision of modern medicine surgeons. This is what the law says. So it is a very gray area. I feel you should not. Don't administer anesthesia to non-modern medicine surgeons.
Then, can an anesthesiologist practice general medicine after doing some short course?
No.
Actually, basic medicine practice anybody, any MBBS can do.
It is family medicine. It is like a family doctor, not general medicine. You cannot treat Guillain-Barré syndrome. You cannot treat stroke, and you cannot thrombolize patients.
You cannot claim you to be specialist. That is
Yes.
Some certificate course as family physician. It has to be recognized by the NMC. Today only the NMC has de-recognized all CPS courses.
All CPS
notification.
Yes. And that family physician, which somebody is asking, that empowers you to be a family doctor. The word physician does not mean MD physician. No.
Yeah, because now there's a family physician course separately also being run by national board. Some people raised hands. Yeah, we are still going through those questions on the, could not see the hands. So, Dheeraj lecture. Write your phone number. I will send the details.
No.
Just a moment.
Yes.
So I think we have a very long and very important and fruitful discussion. Thank you, Nilesh, for taking out your time from your busy schedule.
My pleasure, sir. My pleasure.
Okay, so we now close this. Thank you.
Yes, thank you. Thank you very much. Thank you, everybody, for wonderful questions and a wonderful interactive session. Thank you. Thank you very much.